Ms. Shea, your team compared registry data to the State Department major money laundering country list and found 251 registrations with addresses located in these countries. Your team also compared the registry to the Office of Foreign Asset Control Records and found 6 planes registered to entities subject to U.S. sanctions. Does the FAA have access to the same records you used to conduct your analysis?
Thankfully, this is working out. FAA does have access to that information for that kind of analysis. It's public information. The sanctions list is public, and all citizens are required to comply with it.
Follow-up question to the same one. What did the FAA tell you about its authority to deny registration to sanctioned individuals and due diligence it conducts?
FAA told us that it does not have the authority to deny registration to OFAC-sanctioned individuals or in situations where an aircraft is sanctioned. I'll leave whether that's accurate or not to the lawyers, but one of the things that that does indicate is a significant red flag that red flag and a risk that FAA should be managing. And as a result of that, be in very close collaboration and communication with law enforcement about that and OFAC about that, how to be handling that particular issue. And one of the things that we also found in relation to that sanctioned individual, the case there, while there's 2 different registries, there's the owner registry and the dealer registry, and while FAA had placed a flag for that sanctioned individual in the owner registry, there was no communication between the dealer and owner registries. And the intermediary that had established the registration for the sanctioned individual, who was later sanctioned himself, he was also registered as a dealer. And because there was no connection and awareness on FAA's part, he had registered that aircraft for over a year as a dealer, so was able to use and fly that aircraft, through a valid certificate in the dealer registry because FAA was not able to connect those 2 data sources.
If the FAA were a private company registering aircraft in the U.S. for that $5 fee and it failed to check with the OFAC registry, would it be in violation of U.S. sanction law?
It would be in violation of U.S. sanctions. All U.S. citizens are required to comply with sanctions designations. And I would also add, if that U.S. company were charging just a $5 fee, it would long have been out of business.
Yeah. I referred to the report that I released, and it's about your recommendations. To this day, 12 of your recommended corrective actions are outstanding despite FAA's agreeing with them. In your experience, has the FAA been unusually slow and dangerously negligent in acting on your recommendations?
So I will give FAA a little bit of grace for 2020. We issued our report and recommendations in March of 2020, but it has been 3 years since then, and they have only completed action on 3 of the recommendations related to fraud risk assessment. That's a good foundation, it's a start, but there are many things that should not have taken as long as they have, taken 3 years in order to implement.
In your 2020 report, Ms. Shea, you noted that the FAA identified a risk that terrorists may access the FAA registry. Could you explain the access terrorists have to the registry as well as their ability to register aircraft?
So one of the things that we talk about in our report is FAA's rubber stamp approach, essentially, to accepting registrations. They collect limited amount of information, and they are looking to see that the application form and a bill of sale is present and the application is complete. They do not verify that information. And in our review, FAA did not mention anything about checking the terror watch list, for example, to identify whether terrorists are seeking to register their aircraft. But because of the approach that they take, the essentially not requiring significant information and the minimal verification, I don't see how they could possibly know if terrorists were registering aircraft in the U.S.
So my last question, I think you just answered, and so I'll make it as a statement. Your report is more or less saying that the FAA hasn't taken any steps to deny terrorists access.
I don't think they would know if they have or have not.
Okay, thank you. Yeah.
Senator Grassley is interested in pursuing a second round. I just wanted to thank him for his work
Well, do you want?
in this area. No, I'm good. And look forward to working with him on remedial legislation, and our appreciation to GAO for all their support as we look at this problem. And with that, let me turn it back to Senator Grassley.
Well, I'll just have two questions then and probably submit some for answer in writing. I got one more for Ms. Shea and one for Mr. M. In 2020, GAO recommended that the FAA create written agreements for information sharing with law enforcement. It's been 4 years and the FAA still hasn't signed an agreement. Why did you make the recommendation?
We made that recommendation based on quite a few interviews that we had conducted with agents in the Homeland Security Investigations, the Trade Transparency Unit, the Drug Enforcement Agency, and even FAA's own Law Enforcement Assistant Unit. And in those discussions, we heard over and over about the difficulties that law enforcement has in identifying the beneficial owner of aircraft that are associated with money laundering cases or associated with drug trafficking cases, and the difficulty that they had with the information that FAA collects that could support those investigations, but also the difficulty in receiving that information from FAA. One of the data points in particular relates to declarations of international operations. With these DIOs, they help expedite the registration for an aircraft so that the owner can take the aircraft out of the U.S. within 3 days. And you would imagine that when somebody registers an aircraft at the same time that they file a declaration for international operation, the DIO, it presents a money laundering risk, and the investigators know this. So these could be very valuable pieces of information to the investigators if they were to receive them timely. It takes a lot of time to identify and trace funds so that they can issue warrants and seizures. But FAA provides them on an ad hoc basis, sometimes monthly, certainly after the point at which the aircraft has already left the U.S. So that was one of the areas where we recommended that FAA do a better job of sharing daily information with with law enforcement. I don't think it would require much because there's no barriers that FAA identified to us in sharing those. They already share them, but just doing that on a daily basis, that was one of the things that we recommended, and it's unclear to us why FAA has not done that as yet.
Well, it seems like 4 years is not a reasonable period of time to negotiate information sharing agreement. Are you aware of any barriers to entering such agreements?
No, not aware of any barriers. Again, FAA did not raise any. They share them on an ad hoc basis, so that means that they can share them. And one of the things that we've also done is added some of these recommendations to GAO's priority recommendation list, so they get enhanced attention. We do a biannual report focusing on a couple of special recommendations, and some of these are among them.
Mr. M., your question is only for comparative purposes to what Ms. Shea has said. You served 31 years at DEA, I believe, and collaborated with other agencies. On average, how long did it take the DEA to sign an information sharing agreement with other agencies?
Less than a year. Some took within a matter of months.
Okay. So, did you say originally no more than a year?
No more than a year, from what I recall.
Yeah, thank you very much. I'm